We'll talk later.
Good afternoon.
Quite the delegation. Donna, did you get a chance to talk to anybody about that resolution?
I didn't, but I don't think it's gonna be a problem. I will do that today. I'm glad you reminded me, because it's actually on my desk. I will.
My only concern is I don't know what to do once we got it. I'm thinking of sending it down to the ambassador of Ukraine in DC.
That's a good idea.
I think. She was at the,
You ready?
she was at the State of the Union.
Yes.
Good afternoon. We're here to hear two bills, 1020, House Bill 1029 and House Bill 1397. Is there anybody back there that's signing in for 1029? Okay. Representative, you here to introduce the bill? 1029? Huh? Okay, then I will introduce House Bill 1029 relative to the Claremont Police Commission. According to the analysis, this bill provides that the City Council of Claremont may remove a commissioner from the Police Commission. And last I knew, there was no one signed up on the sheet. Is there anyone here that wants to speak to House Bill 1029? Seeing none, public hearing is closed. That one should be an easy one to write up, Trish. And we won't be back until quarter after, I guess. Good afternoon again. The next bill is House Bill 397. And Representative, if you're here to enlighten us, we'd appreciate you coming forward.
Thank you, Mr. Chairman, and thank you to members of the Election Law and Municipal Affairs Senate for hearing me. My name is Doug Thomas. I represent Rockingham 5, which is Londonderry. I'm a co-sponsor on 1397 because our county officials, the four of them that are named in this bill, wanted this bill. So we felt it was appropriate to submit it. It's obvious that there's a very heavy workload in Rockingham County, and our county officials are very heavily involved in running the county. To have elections every 2 years with both the money and the time a factor, they barely have enough time to get their job going the way they want it before they have to run for election again. So they felt that a 4-year term would give them better time to attend to their business of the county and to provide exceptional service. Now this bill was, and I will just add here, I apologize for not having a written testimony. I can provide one upon request, but the points I just want to make are that county House committee, and it was approved 19-0 with an amendment. When it came to the House, the bill was pulled off of consent because there were some counties that felt that maybe they didn't want to be included in the overall bill because the amendment had included all the counties, not just Rockingham. The discussion, I believe, was justified, and the amendment failed in the House because it was felt that each county should decide for themselves if they want to convert to a 4-year term. As far as Rockingham County is concerned, we want the 4-year term. So I believe people after me will be speaking to the details on why this would be an effective way to run the county, and I would ask the Senate here to consider passing this bill as it is, so we can, so Rockingham County can proceed with their new election format, and perhaps the rest of the state after that can find out how it actually works. If you have any questions, any detailed questions, I would defer to the people behind me, but otherwise I'm here if you have a question.
Okay, questions from the committee? Senator Ward.
Thank you, Mr. Chair. Thank you for taking my question. I noticed the 4 years. Most of the other terms that I know of are 3-year terms. Why 4?
Well, I'm not aware of, well, we know that the county commissioners are different years. That's why they weren't included in this bill. As far as the other counties are concerned, I can't speak for them. I don't know, but the 4-year term, I believe, is a historical average of, some states have 2 years, some have 4 years. I think 4 years is a good round figure to get their business done before they have to start campaigning again. That would be my opinion.
Follow up? What other positions in the New Hampshire government has 4 years? Do you know?
I am not aware of any other positions.
I'm just curious because
yeah.
I know the select board is 3 years and other.
I think various towns have, thank you for the question, Senator, but I think other towns can, if you're talking about town, I think their terms are different. State, I don't know of any other 4-year terms. I know commissioners are appointed, so, but as far as election goes, I'm not aware of any 4-year terms, but I don't think that's a big issue for Rockingham County, though.
Thank you.
Additional questions? Seeing none, thank you very much.
Thank you.
All right. Have I got any other representatives out there that were looking to speak? I don't see anybody here. All right. Kathy Stacy.
Good afternoon, Mr. Chairman of the committee. My name is Kathy Stacy. I am the Rockingham County Register of Deeds and also the legislative chair for the New Hampshire Association of Counties. Because we can support this bill. And a few of the things I just want to be very brief in my comments. my position and the positions that we're talking about, the positions, are really administrative in nature. It takes quite a bit of effort to get into your job and do it well and learn everything you need to learn, especially registry of deeds. We have to deal with literally 100+ pieces of statutory requirements for recording of deeds and so forth. You know, we have to develop relationships with, I have to, with the Department of Revenue because I'm the agent for the Department of Revenue, with vendors, with title companies, surveyors, attorneys. It takes time to do that. The other thing is, when you're dealing with a 2-year term, you know, the first year you're in there, you're doing your job, but the second year comes around and you start to really think and focus on election time. Not only for myself, but for my staff, which really disrupts the office. Believe it or not, because when you're dealing day to day in that office, people are concerned with what's going to happen with the leadership in the department. I will tell you that the commissioners have a 4-year rotating term throughout the state. Current commissioners do already, which is done for consistency. So you don't have somebody new coming in, you know, so you have a rotation, so that somebody who's always in that position and has been there and knows the function of what's going on. You know, I can't say enough with regards to the time that's needed, especially in my position, with real estate the way it is and how busy it has been, that when I'm looking at implementing new programs or technology in my office, it takes longer than a year or 2 years to be doing that, because you really have to take the time to investigate, to you know, visit other sites to make sure that whatever you're going to be doing, spending taxpayer money, you're spending it appropriately and wisely to make sure that your office is going to function appropriately. That is one of the most important things for my office. I'm happy to say that I have 100% of my information available online to the public. That's something I have done over my term that I've been in office for the registry of deeds. My stuff dates back to 1629. I'm the only county in the state that has that, can say that. And that is because of my diligence in investigating and looking into ways to save money, to obviously streamline the functions in my office. You know, when I started at the registry, I had 24 employees. I'm down to 13. And that takes time, but again, it's about technology and paying attention to what you're doing and how it affects the taxpayers. So we'd really like you to, consider changing into a 4-year term. We think, because of the fact, especially because these are all administrative functions that we perform. We're not doing legislation. Obviously, anything that the legislature enacts, we have to impose, and we do that happily. But again, it takes time, and we want to make sure that we're doing it effectively. Thank you, and I'll entertain any questions.
Questions from Commissioner Senator Susie?
Thank you. How large is your current staff?
13.
And do you know how large the staff is in Hillsborough County?
That probably, it might be similar.
I'm sorry. I'm sorry. I couldn't answer that question. I'm not really sure,
Okay.
but it would be probably similar. She may have a little bit more than I do because her technology is different than what I have.
Okay, thank you.
Thank you.
Additional questions? Seeing none? Oh, Senator Bertzel.
Thank you. Thank you for taking my question. Have the county delegation, are they in support of this?
Yes, they are.
Okay. And just to be clear, so we're talking about the sheriff, the county attorney, the county treasurer, and the register of deeds?
Correct.
Okay, thank you.
Thank you.
Okay, thank you very much. Next on the list, I have Paul Halverson.
Good afternoon.
Welcome.
Thank you. I'm Paul Halverson, currently your Merrimack County Attorney. Before I begin, I want to point out when you ask questions, if I ask you to repeat something, please bear with me. I have a pretty profound hearing loss on both sides. I spent 21 years in the military and got have a pretty good hearing loss. So If I ask you to repeat something, please bear with me. I would hope that the committee today amends the suggested legislation back to the amendment that the House had. The considerations for doing that lie in continuity and policy reasons. The county attorney's office, and I'll speak generally for county attorney's office initially, the county attorney's offices have large staffs. They have interaction with many, many police departments. Using my county as an example, Merrimack County as an example, I have 27 police departments, plus the state police, Marine Patrol, liquor enforcement, so we're talking over 30 departments that I have to establish personal relationships with. We have, with those departments come several hundred police officers that the county attorneys, the assistant county attorneys have to establish working relationships with. All those relationships are dictated by the policies and the direction of prosecution that the current county attorney tries to get into place. That takes time to develop those relationships, establish those priorities, work through problems, fund initiatives, follow through on initiatives. And to be quite frank about it, 2 years makes that very, very difficult. There's always a transition period when a new county attorney comes into office that even delays the beginning of those events even further. So by the time you get going, you're behind the power curve to begin with, to be quite frank about it, with a 2-year term. I have 32 employees in my office. All the attorneys are at-will employees. And as at-will employees, they're reappointed with every new county attorney. And it's important for them to also have continuity. And the other county attorneys that I spoke with also commented about that. I would note that of the county attorneys, to highlight those, everyone that I talked to is in support of readopting the amendment that was over at the House, to include Pat Conway from Rockingham, Tom Velarde in Stratford, John Coughlin in Hillsborough. And I named those three specifically.
Let me,
Certainly.
because you're confusing me, and I want to try to make sure the testimony isn't confusing to everyone.
Certainly.
All right. And the House had an as-introduced bill.
Right.
And then the House made an amendment.
They did.
Okay? And I'm trying to make sure that I understand whether you're talking about the House introduced
The
or
House
the
amended.
House amended.
The House amended.
Okay, thank you.
Yep. I bring out those three counties specifically because they have large staffs. And again, they face the same problems that, that my county faces, that Merrimack County faces. The initial conversation we had at the House, prior to the House amending it to include all county positions in all counties, we discussed two items that were of interest to the individuals at the House, and I want to touch briefly on those two here. One is there was a reference to a pilot project within Rockingham County. There was some confusion about that, and frankly, I'm still confused about whether that was the original intent of the initial legislation, and I'll defer to the sponsors about that. But I did note that there was no, if it was discussed as a pilot project, there was no criteria to measure the success or failure of establishing a 4-year term only for Rockingham County. There was no committee to evaluate any criteria, and there wasn't a sunset provision should the 4-year term not be a success on a purported trial balloon amendment for Rockingham County only. There was also some discussion about going to a 4-year term from a 2-year term, about removal from office. And legislatively, statutorily, that already exists. So there's still the avenue for a county delegation to remove a county attorney, a county official from office within the statute. So the bottom line for all of those reasons, continuity, importance to establish the relationship, management of personnel, management of budget, and the long-term effects of having difficulties in doing those things, I would ask that you readopt the amendment, include all county attorney or all county officers, and for 4-year terms and apply it across the board for the entire state. I'll gladly entertain any questions, clarify any comments that I may have confused the committee about.
The thing that's in front of the committee is the House as amended version, so.
My understanding was, I'm sorry, my understanding that,
Sir, what is in front of us is the House amended version. Okay. Oh, did it
as
fail
introduced,
in the House? Okay,
right.
I sit corrected.
Now, my understanding, just to make sure I'm clear, my understanding was the as amended version was amended on the floor back to the as introduced. Am I correct with that?
I'm looking it back up right now. Yep. Okay.
So that would be my request to return to the amended version.
All right.
I'll gladly entertain any questions that anyone may have.
Questions? Senator Bertzel.
Thank you, and thank you for taking my question.
Yes, ma'am.
Do you know why it failed on the floor?
I do not. I do not. I did not receive any feedback from anybody, so I have no direct knowledge on why it did not pass on the floor. But it did pass out of committee. If my memory is correct, 19-0 out of committee.
Follow up?
Yes, ma'am.
Have you talked to your delegation, the Merrimack delegation, to see if they would
I
support?
can tell you that the members of the delegation that I spoke with when we talked about this as a matter of conversation understood it, and everyone that I spoke with mentioned they were in favor of it. I would not want to mention individual names because frankly, I don't remember the individuals I spoke with, but I remember there were several Board of Commissioners meetings where I spoke with individuals, and at recent budget conferences over the past 4 or 5 months, I spoke with several individuals, and they indicated they were in support of it.
Thank you for your service.
Yes, ma'am, thank you.
Additional questions? Seeing none, thank you very much.
Thank you, sir.
And the next one on the list is Dominic Richardi. I'm sure I've butchered it, and you can correct us. Yeah, just lay him on the table, she'll take care of him. Welcome.
Good afternoon, Chair, Senator Gray, and the committee. My name is Dominic Ricciardi. I'm the High Sheriff of Carroll County. I've served over 32 years in New Hampshire law enforcement. I'm the current president of the New Hampshire Sheriff's Association. I'm here to testify in support of HB 1397 with a proposed amendment on behalf of the association. The second page of that handout is the proposed amendment. When this bill was heard in the House Municipal and County Government Committee passed the attached amendment, vote 19-0. As you know, it failed in the House floor by a vote of 150 to 189. The association feels strongly that it only makes sense for continuity that if this bill passes, that all counties should be included. For sheriff's work and consistency, a 4-year term is more appropriate. We all know that it takes a lot of time and effort to campaign and win. If an elected sheriff had not worked in the sheriff's office prior, then the learning curve is far greater. They need to learn what employees and positions are already in place, what special units are currently in place. 8 out of the 10 sheriff's offices in New Hampshire have their own dispatch units and budgets. Once one takes office, they need to look at what policies and procedures are in place and if they are working for the office. Any consideration to make policy and procedure changes, again, takes time. By the time you are at this stage in a normal 2-year election cycle, you would probably need to start working on campaigning again for the next election. A 2-year term is short for any consistency and to implement changes that may very well be necessary in the office. Currently, I have found that only the state of New Hampshire has a 2-year term for sheriffs. All other states that elect sheriffs are 3 to 6-year terms. Having any one county with a different election cycle and term lengths for these elected positions would be the epitome of inconsistency. I again would ask you that you amend HB 1397 to include all 10 counties, and I thank you for consideration. Be open to any questions.
Questions from the committee? Seeing none, thank you very much.
Thank you. Thank you.
Is there, could you check and see if anyone signed in after I got the sheet? Oh, all right. Three other individuals signed in supporting as amended, not speaking. And with that, I'll close the public hearing. Do I have a motion to go into executive session? Do I have a motion and a second to go into executive session? All those in favor say aye. Aye. All those opposed? All right. I'll let you grab your papers. One thing that I did send out to you, we got some communications from some of the executive counselors asking that we consider some changes. I am certainly not in favor of doing any of those changes. The calculation for population deviation that I came up with those changes is 9.42%, which is, as you've heard me say many times, population is one of my main considerations that I've done in any of the maps that I've drawn. So unless any of you want to bring up anything, then I intend not to talk about this anymore. Okay, moving on to the other things on our plate. Bills to exec. SB 243, permitting the transfer on death. Last I knew, we were worrying about where they were going to have to make sure that that declaration of turning down an inheritance or a transfer was going to be recorded. What is the status of that, Senator?
Yes, Chair. So I did speak with OLS about that. We did decide to draft an amendment. I think I released the amendment to committee through CAM. You don't feel like you have it? Give me 5 to 10 minutes and we will try to have the amendment here, but I do have a draft of it.
We'll put it on hold for right now.
Thank you very
and-
much.
So, Mr. Chair, are you planning on execing the 1397 today? Because if not, many of them are probably waiting.
In 1397, I don't fully understand what went on in the House floor. And without that information, I think that I'm at a disadvantage in trying to make a decision between the as introduced in the House version and the amendment that failed. Just to correct one of the speakers, that not all of the county commissioners are elected on the term. Stratford County is one that elects their county commissioners throughout the whole county every 2 years. You know, we right now do have things that we do, especially with county commissioners, where some serve in districts and are elected on various bases and other things. I think that understanding what went on in the House is something that I want to know, and unless you guys outvote me, I intend to wait on that one to take any action.
No, I just wanted to make sure that if they're waiting for this to be exec, if we're not going to exec it, then they can go on with their day. That's all I'm.
Is there any senator that feels the need to bring up a motion today? Okay, we will not be execing that one today. We will exec it in the future. .348 is the next one that I have on the list. current status of 348, since I haven't discussed any changes with anyone except Senator Susie, and they are the changes that were sent by the Attorney General's office. What I've suggested to her is that we do eliminate the words on page 1, line 18, where it says partnership or union, and then add to page 2, a section Roman 6, which would pretty much mimic the words that the Attorney General said were federal campaigns. A partnership or labor organization may establish its own political committee, which may take contributions, may make contributions to a candidate, political committee, or political party. And to that, I suggested that we reinforce that they have to be segregated funds received from the members. But right now, Senator Susie and I are still discussing that one. So
So
I'm
we're
going
going to
to-
hold off on this.
going to hold off on it. We have not written the amendment yet, even
Right.
to do the things that I had suggested.
Okay.
It is not an FN. I just wanted to give you the status of what was going on with it. Okay, the next one on the list is 405. Oh, I didn't do 365 yet, did I?
That's correct.
Absentee ballot outer envelopes. $365, current status is, there was an amendment, 2022-1077S, and that pretty much adds on line 26, on page 1, the voter address. I think it may have been sent out electronically, but I don't know who had it and didn't get a copy.
Thank you, ma'am. Copy, please. Thank you. Oh, but this is a whole new section.
You had to put in,
Replacing section.
since the original bill didn't do any of that, you had to add that whole section in there to get it in. Adding that address was from the Clerks Association to help them identify one ballot from another. They say people like me, sometimes the signature is very messy and hard to recognize.
Go figure.
Again, doing away with the outer envelope will help, will give the opportunity to cure any defect in the signatures. That we found that very useful when they were opening the outer envelopes for the pre-voting for the COVID, that many of those ballots that had problems, they were able to correct them. This takes it out of the absentee process. There's no reason that I was able to come up with, or in statute or other place, that required that outer envelope except a vehicle to get it through the mail, put the stamp on, have the addresses on. So this recognizes that. It takes care of that one problem the clerks came up with. And so if you agree, I would accept a motion on the bill and the amendment. So it sounds like we
Second.
have an auto pass on the bill
Second.
and an auto pass on 1077S. And that was Senator Birdsell and seconded Senator Susie. Okay, and we'll do that on both. Any comments, discussion? All right, on the amendment? Discussion? All those in favor say aye.
Aye.
All those opposed? And on the bill as amended? Further comments?
I think it's a positive step, as you said, Mr. Chairman, particularly for the opportunity to cure ballots.
Thank you for both of your work on this. Appreciate it.
Okay. All those in favor say aye.
Aye.
All those opposed? And I'm just as happy with consent.
Move
So
consent.
moved.
Okay, all those in favor of consent say aye.
Aye.
Opposed? And I guess I think it was my bill to begin with, so
Is your bill.
I'll take it out.
Go back to 243.
Thank you, Tricia. Thank you.
Okay, it takes care of my objection to it. And
Okay.
we'll make it much easier on those people that are trying to research those deeds, I'm sure.
Agreed?
Could I just ask one quick question?
Of
about the
course.
amendment?
Absolutely.
The 60, within 60 days of death, it's because the person already is on notice that they're going to be a beneficiary, so 60 days is enough time to trigger.
Yeah, well, they should be on notice, but if they're not, 60 days should be sufficient
Okay.
for the beneficiary to record, a disclaimer. But I think what needs to be balanced with that is just the interest of the state in having title quiet and,
Right, right.
moving expeditiously. So I thought 60 days would be reasonable if you all agree.
Okay. Need a motion to move the amendment?
We'll need a motion on the underlying bill and the amendment if we're moving the amendment.
Ought to pass on the bill.
Second.
Okay,
I move amendment 1033S.
okay. N33S. Further discussion on the amendment? Seeing none, all those in favor of the amendment say aye.
Aye.
And all those opposed? And now the bill is amended. Further discussion? All those in favor say aye.
Aye.
And
Move consent.
opposed? Well, I
Okay.
gotta say the word.
I know you do, I know you do, Mr. Chairman.
And I think we just had a motion for consent.
So moved.
All those in favor say aye.
Aye.
Opposed? And since this was Lou's bill, give you ladies first choice.
I'll
Your
take
work
it
on the
up.
amendment.
Senator
Sure.
Perkins Cuoco. Okay.
Now, and I apologize, was I supposed to, the concern we had was shall versus may on this. Was I supposed to verify this with the, on 405?
Let me,
You know what? I have Phil notes, and I don't have a note on that one.
Oh, I'm sorry, I wasn't.
what's all
You may
right?
not want to go to this bill yet, so,
It's next on the list.
you know. Well, on the amendment on line 27, first page, first page, it says the Attorney General shall notify suspected violators of this section of the state's intention to seek civil penalty to negotiate. We weren't sure whether it should be shall or may.
Which bill are you talking about now?
405.
Okay.
And it's Amendment 0856.
Yeah, I'm sorry, yeah.
Yep.
Okay, so, I guess it's going to be a committee amendment because this is an FN. And we need to take care of it today. Unless we get so far gone, then we'll recess for however long it takes them to make an amendment, if we can't come with the committee amendment.
Is there what would be the benefit of doing shall versus may or vice versa? Rick, do you have any insight?
Is this line 17?
Correct, 27.
27 was the second one, okay.
On line 17, there's
Yep.
may, and on line 27, there's shall, which we were worried if that goes to prosecutorial
And that-
discretion.
Attorney Lehman, if you want to speak, you're gonna have to get to a microphone. And if you want to think about it for a minute, we need to turn off at least one mic so that you can turn yours on. All right.
So it sounds like the question is whether I don't think using the word, well, the criminal code is full of instances where it says a person who commits X conduct shall be guilty of a misdemeanor. That's the way the word shall is used in criminal code. These are civil penalties. I still think that the Attorney General has authority to determine whether to pursue a civil penalty against anyone regardless. But it seems to me,
I think that my problem was that if they are trying to decide, and it gets, put off for a while, then they would have an argument, you didn't tell me, so I'm good to go, where may leaves them with their option so that it doesn't have any time period or anything. I mean, they may make a decision and they may change their mind. But if you've made a decision and you shall notify, then once you've notified, I don't think you have any option. So,
well, this paragraph has to do, I mean, the word shall attaches to notify, it doesn't attach to pursue civil penalties, right? And I'm trying to think of an instance in which the Attorney General would seek civil penalties without notifying the person they're seeking the penalty from, and I can't really think of one offhand. So if the Attorney General is going to seek civil penalties, then the target is going to be notified. And it may be through a court process rather than or an administrative process, really, rather than a letter from the Attorney General's office saying this is our intent. But you can't seek a civil penalty from somebody without telling them that you're going to do it, because they have a right to notice and be heard.
But then look at line 17, which they're changing to may notify. And I think part of our concern was that the two were inconsistent, even though they're not citing the same violations. seemed inconsistent to us that one was may, one was shall.
Yeah, well, so I'm a little disadvantaged. Couldn't even tell you what 644, 14, and 17 are. I assume that they are notification on political advertising of who paid for it, basically. I guess my reaction is, and again, without having seen the whole statutory structure that's built up around it, is that if you're going to give the Attorney General authority to pursue civil sanctions against people who violate substantive restrictions on political advertising, that it's inherent in authorizing the Attorney General to pursue penalties that there's going to be notice before any penalty is imposed. You can't impose a penalty on somebody without giving them notice and an opportunity to be heard. So whether it's a mandatory statement of intent from the Attorney General to an individual, or if it's something that's generated the way a complaint is in a criminal case, in either event, the person's going to be put on notice and be given an opportunity to be heard.
So for consistency purposes, we should use shall in both instances.
Yeah, I mean, you should be consistent. I'm not sure that either of these provisions is required exactly, because the act of seeking a penalty requires notice. Again, not knowing the statutory scheme, who adjudicates the imposition of the civil penalty in this structure? Is it the Secretary of State's office? Is it a court?
It's the Attorney General.
So the Attorney General is the administrative body as well as the prosecutor? Okay. This wouldn't be the only instance where that's the case. So somebody at the Attorney General's office is responsible for sending notice, and it could be either whoever is adjudicating the question or who is presenting the evidence.
Say that again?
I'm not sure that it's necessary to have a statute requiring the Attorney General to give a statement of their intent, but if you're going to have it, you're right, you should make them the same. May or shall, I don't think it matters.
Well, I think the whole concern on this was that they weren't implementing it,
So
from what I,
people were getting notices that they had been fined and were being asked to pay money without a hearing of any kind?
this is Senator Guida's bill. So he had an example of a moderator in his district who asked a police officer to remove the lawfully placed signs of a candidate he opposed. Virtually no penalty was imposed. He believes they need to put teeth into the election laws, and this is his way of doing it. They need to make it clear that if you violate election law, there will be consequences. And this was the language, by the way, that the Attorney General's office had given me. All we're looking for is, because he was trying, I was working with him on it, he was trying to clean up some of the language. So the only question we had, because again, this is the Attorney General's language, the only question we had was whether line 17 and line 27 should be consistent.
I guess since this is a fiscal note bill, it has to be out of this committee today. My recommendation would be to use the language the Attorney General provided you, and then I'll communicate with them and figure out what's going to make for the best floor amendment next Thursday. Does that make sense to the chair?
Certainly that's an option. I might tend to go in, and since existing law had shall on both occasions, to change it to shall, and then suffer the consequences if of the floor amendment if I'm wrong. But then again, that gets me back as close as I was to the existing statute, with two shalls in there.
I would agree, I think. We can always be corrected in finance if there's a reason.
I don't think this is going to be hard to square away.
Okay,
It's just going to take some time and familiarity, that's all.
Maggie?
so,
So we're going to,
So on line 17, we're going to keep the word shall. I don't think we need to have authority to. I think we shall notify. The same
no,
as it is.
17 is May.
right, we're going to cross off May.
No, we'll restore the shall. but it
Okay.
says Shall have authority.
Yeah,
I mean, I think it's just shall notify,
yeah.
the same as 27.
Yeah. Okay, so we have a ought to pass motion on the bill made by
So moved.
Birdsell. Seconded by Ward. Okay, and we have an ought to pass on Amendment 0856 with a committee amendment to change the word in 17 May back to shall.
So moved.
Second.
We have a motion and a second on that. Do we have any further discussion on the committee amendment? All those in favor say aye. Aye.
Aye.
All those opposed? Committee amendment passes. OTPA is where we are now. Is there any further discussion? All those in favor say aye. Aye. All opposed say nay. Okay.
If you want, I'll take it.
And because we have the outstanding question,
No, it's not.
we won't put it on consent. We'll leave it off. And since Senator Birdsell was working with this one, she's going to get to take it up.
Is it 5-0?
Yep. The next one is 418. We'll be in recess for 5 minutes.
Senator Gray, did you want me to pass those out?
Yeah.
And does everybody have the amendment before 18? Is it 1043? Yeah.
Okay, we're back. In addition to the amendment, I passed out these sheets here. And the reason that I passed those out, this is the actual application form, and what you see highlighted in yellow are the things that are not printed on the checklist and would be information that was not subject to RSA 91A. So you have place of birth and date of birth, you have driver's license number, and if you don't provide a driver's license number, we request the last 4 digits of the social security number. And part of the amendment, as I wrote it, says that if someone presents themselves to one of the ballot clerks or inspectors of election, whatever as the case may be, and they don't have the valid ID, that ballot clerk, et cetera, should send the person to the supervisor of the checklist. In those communities where the supervisor of the checklist has internet access, they would be able to go into ElectionNet, see all of the information in there. There's also other information that's in ElectionNet if you have moved, that ElectionNet actually still retains the old addresses. And some other information that I'm not quite sure exactly how much there is or whatever, but it's that type of information that would be, you know, they may contain the addresses where absentee ballots were sent. They may contain other things. And I do not know for sure that they do have that, but that's the type of information that could be available. So that if someone comes up and, gee, I forgot my driver's license, and you go and say, okay, well, I know these 3 or 4 things, which of those can you tell me? They give you the date of birth, or they give you the last 4 digits of social security number. I'm not really interested in them having to fill out an affidavit to prove, since these are all people who are previously registered to vote, et cetera. And that's why if, through the training, the Secretary of State would provide that, we could hopefully eliminate any people that would be subject to an affidavit. As we move to other systems, this committee has passed the portal information. In the portal, to get a login to the portal, you will never have anybody looking at their ID. You may give driver's license number, we may check that against that. You may ask for their second cousin's, mother's, father's maiden name, you know, or whatever. Which of these 3 addresses looks familiar to you? And, you know, all of those same questions that many of us are used to seeing to verify our identity. So I eventually would like to see that incorporated into the election law. I didn't quite go that far this time, except for those people who are already registered and looking at information that we already request on the registration form. Although when you get somebody who registered as far back as I did, some of that information wasn't on the form at the time. But some of that information may be available based on whether or not we can use the DMV records. So then you come down to this bill, and then you get to the main thrust from Senator Gaida, and that's the provisional ballot. And I have consulted a couple of different people on whether or not it would be found constitutional. The overall opinion is that, you know, there are people out there who think that our Constitution would not allow a provisional ballot. The argument that they gave me, I didn't tend to agree with. And that the fact that you are, you know, trying to do something to ensure voter integrity is certainly something that is important to a lot of people out there. How many, there's no way to know. So with that, I'm going to shut up for a few minutes and listen to anybody who wants to talk. Senator Perkins-Coker.
Yeah, thank you, Chair. So I guess I have a few concerns. I mean, it seems that what we're still trying to do is isolate these affidavit ballots, and you seem to be using the term today, provisional ballot. So I guess some of my concerns remain with that. I mean, the ballots are isolated and in a box, and so those are available differently for presumably kind of opening to be looked through, which I know, you know, we had the town moderator in Derry here, and she said normally, you know, we really don't open the ballot boxes, so I have concerns about the privacy there. And then, you know, I think probably my biggest two concerns come from the idea that for same-day registration, you know, we're potentially making the requirements different than we are for registration prior to election day. So specifically, I'm looking on page 1 of the amendment on line 30. You know, requiring citizenship is something that we've raised, or I think was raised at the hearing, and I know you're saying, you've talked to folks who are saying this amendment might be constitutional, but, you know, I'm certainly hearing that requiring citizenship proof for same-day registration would not be constitutional. I also think in having that sort of discrepancy between same-day registration requirements and pre-registration requirements, where we're losing our sort of quote-unquote continuous same-day registration system. And so, you know, that certainly puts in jeopardy our ability to have our national voting Registration Act exemption. So I think, you know, I have many concerns with this, but mostly, I guess, you know, I don't think there's a problem. So I don't think this needs to be fixed. And I think we have fair elections, and we've heard the Secretary of State say that. We've heard others come testify to that. This creates a lot of confusing procedure that potentially disenfranchises our voters if they don't return paperwork within 10 days. I don't know if anyone's ever forgotten to do something, but, you know, that's another concern. So I'd like to continue talking about it, but that's just a few of the points I would raise initially.
Additional comments?
If I may, Mr. Chairman, I
Senator Susie?
have two more minor concerns and two bigger concerns. The more minor concerns, and I don't know that minor, but on page 2, you're still requiring the distribution, line 4, of a prepaid postal service, Priority Mail Express overnight. I know the fiscal note says that it's indeterminable, but I know the cost of certified mail is like $7 a piece, so I can only imagine having to prepay for all of these statewide, not knowing how many you're going to need, so you're going to need even more than what's required, is a significant expense. I also think on page 3, the verification process that's on line 24 and 25, I'm not super familiar, but if everybody is using ElectionNet on election day, whether it's Citizen Access or others, the potential for that to be overloaded and to not function well in some of the polling places is a concern. But my two bigger concerns really are around the provisional ballot portion. I certainly share the concern about privacy, but I very much am concerned given, and you know, you and I are on the same side of moving our primary, but until we actually do that, with a September primary, if the election results are at all close, and those results could change because you're removing ballots, I think that's a real problem for the UCAVA ballots and getting those ballots out, particularly overseas, and pitting us against potential violation of federal law. And then the bigger thing really is the fact that if part of the impetus for this legislation is voter confidence in our system, to announce results one night and then to have the results change later, I think particularly for our First in the Nation primary, which I was just at a meeting where there was a lot of discussion about that calendar, I think that's really problematic. I mean, what happened in Iowa, I know it's a caucus, it's different, but the fact that results weren't out that night or that results could be out and then change, I think does more to undermine confidence in the system than it does instill confidence. So for those reasons, I still have a concern with this legislation.
Okay, additional comments? From the things that I've heard, the citizenship issue, right now the supervisors, the checklists are trained to deal with the supervisor, excuse me, the citizenship issue. And so, you know, whether it's in here in these words or other words, that training, those criteria still apply, whether you registering on election day or any other day. The cost was brought up on page 2. Certainly that will be, if this bill passes and goes on to finance, it will be an issue that can be brought up there, and appropriately so. Page 3, the brought up lines 24 and 25 about overloading. Certainly how the Secretary of State would train the supervisors of the checklist. The reason that is very vague in there is because you can find out an awful lot of things on the internet, and if I know exactly what the questions are going to be, you know, I can go look for answers before I get there. So what that training is, what kind of things would be required, is certainly in a place that doesn't have internet access. It may be a list of these 3 or 4 things that are non-public information. And so, again, each of these people, whether I'm filling out an affidavit or whether I'm having the supervisor actually look the thing up before the affidavit's found out, I don't see, you know, a big difference in there, but certainly that things that could happen. So I guess if there's no other comments, I would start accepting motions on the bill. Senator Perkins Coker.
Yeah, just to clarify, Chair, so, and thank you for responding. I mean, I think what I'm raising in terms of citizenship is that, you know, the intent here is for us to be able to provide an affidavit for citizenship, just like we do for domicile. And so that would be changing pursuant to all of the procedure that's on page 2, just to clarify. And, you know, I think, thank you for responding to the issues that have been raised so far. I mean, in my mind, there are further ones, which is, you know, essentially this could become really burdensome for the Secretary of State to administer. I mean, on line 25 of page 2, it says on the 10th day after election, if the voter has failed to return the verification letter, either in person, writing, Secretary of State shall instruct the moderator. You know, I don't know how many of these affidavits they'll need to verify. I don't know what their process will be for checking them as they come in, but what, you know, I guess, what happens if they're late? What happens if this becomes a large number of affidavits? I guess you know, I'm not trying to be worst case scenario, but it feels to me like a huge sort of addition to our election system that's based on the idea that people are filling out these affidavits, and that they don't take that seriously to be telling the truth. So I just don't see the need, and I'm concerned that, like Senator Susie raised, I mean, this is just going to create uncertainty around the results of our elections by making all of those ballots essentially provisional.
Thank you.
Move ought to pass.
We have an ought to pass motion, and I'll second that. And do we have a motion on 1043?
Ought to pass.
And I will second that. Okay, further discussion on amendment 1043? Yes. Seeing none, all those in favor say aye. Aye. All those opposed, nay.
Nay.
And I got 3-2. Ought to pass as amended. Further discussion? All those in favor say aye. Aye. All those opposed say nay.
Nay.
And I will take that one out. $4.27.
What was it, 4? I got it.
I think I may need the amendment. Thank you, ma'am.
Oops. Oh, we did, wait a minute, did you say 1065?
Okay, which one are we doing?
1065, yeah.
Okay.
Your,
Said the other copy, I have the old copy.
it's your amendment.
Yep. We just had the wrong copy in my book.
Which one are we doing?
We're doing 427.
So, Mr. Chairman, if I could,
Yes, ma'am.
when we talked about this issue previously, the concern, so is, the bill does two things. One, it tries to address the issue of people that, because of conditions that they don't personally deem a disability, would allow them to still have an appropriate marking on the ballot to request an absentee. And the other was the issue of pre-processing, which starts on page 7. But the language that I use, so the first 6 pages replace in each of the sections regarding registration and application of absentee, other than gender changes, the only other changes are that where it says physical disability, we would add illness or other medical condition. As I said, the reason is that many people take the term very literally. I know we talked about how it's defined in the dictionary, but for a lot of people, being concerned about having exposure to disease is a primary concern and a reason why, but they would want an absentee, but is not deemed a disability. And heard certainly from folks from the Disability Rights Center that there are certain things not categorized as disabilities in their mind and in their practice. So this was an attempt to address that with this language. And then, as I said, beginning on page 7, line 20, section 8, was the language which mirrors the language that we had previously applied relative to pre-processing of absentee ballots.
Okay. So this abandons the no fault?
Correct.
That's correct, Mr. Chairman. This abandons the anyone can apply for an absentee. This is strictly to provide an additional reason by which somebody could apply for an absentee.
Just one reason? The illness?
No, it adds illness or other medical conditions. So currently, the reasons are a physical disability or
Right.
if you're out of town. It retains those, but it adds language separate from the term disability. So it is not, for lack of a better term, no excuse absentee. It's just an additional excuse to apply for an absentee ballot. And that's why I had version 1000, because originally version 1000 was still no excuse, but this is not.
Okay. I was just taking a few minutes to go through it.
Absolutely.
Page 6, line 14. To be consistent with what we did
Yes. We
in,
need to, is it 320?
The address?
Yep. In 365?
I think that's the one.
Yeah.
Voter address. Page 7, lines 24 and 25.
Yeah, go back to 365.
The problem with this, starting down in this section, is that if we're going to no outer envelope, then this starts to become confusing and certainly one of the things that I've always objected to is going from the 2 hours down to the 1 hour, because if I find out that Governor Cuomo has now been indicted for whatever, and I voted for Governor Cuomo.
I want to get my ballot
I want to
back.
be able to go down and vote in person, and restricting that down to 1 hour, you know, it used to be all day. Well, you know, I had to pick somebody, you know. Down at the shipyard, they use the name Charlie Fanaris, or, you know, just a name.
Yeah.
Okay? So in this case, you know, I used a politician whose reputation might have
We got
been
it, we got
soiled.
it.
So
So, Mr.
I'm
Chairman,
good,
if I
I'm
could
good till I
suggest-
get into that section, and then it's gonna take me longer to,
So, Mr. Chairman, I do feel strongly about pre-processing, but if that's going to be an obstacle to passage of the bill, I think what would be more important, if I had to choose, was the first 6.5 pages.
yeah, I mean, there's certain portions of this that I don't have a problem with.
Okay?
I do have a problem with the 1 hour vice
Yeah.
the 2 hours.
Where are you in the bill? What page?
We're on page 7,
Line
Line
29.
and we're starting on line 26 and then moving down, actually 25 and moving down, because I think that provision on 659-49B was put in there because of the changes that were made below.
Right, so we could remove at the end of 24.
We're not going to have a presidential election, which is when the biggest problem comes about for processing absentee ballots.
Right, and with the passage of your bill, with dealing with the envelopes, I think pre-processing does two things, right? One is the workload issue, which we were trying to combat during the presidential, but I think the other thing it does, and that certainly was a big credit to clerks that were persistent in assisting voters, it allows voters time to cure. So ideally, the passage of your bill without the envelope will give that opportunity earlier as it's received to cure, because typically it's the signature issue.
Yep.
So I think if we were to strike out section 9 through,
You may
9
have
through
to actually
11.
go back into 8. Because 8
yeah, we would
is,
need 8.
So we're striking out 8 and 9?
So we would strike out 8 through 11?
Oh,
and 65950C. I didn't bring my law book with me.
That's the
Oh,
signature comparison that was struck down by the court. Nope, that's a red book.
yeah,
That's the results.
that's all right.
I can pull it up on my phone.
Because we're repealing 65951C.
It was the
And
signature match issue that the court had struck down.
Where are you? Can I ask for
We're-
clarification?
we're on page 9, we're talking about 12, which is on line 5 and 6. Because if we go through and strike 8 through, I think you really want to strike 8 through 12. But I'm trying to figure out what 65950 Roman 1C is. And I thought it might
What
be
was it?
something we were
659?
enacting in here.
No, it's not. It is.
announcement by moderator.
Yeah, no, it's the section dealing with, and I'm trying to, our site, since it's changed, is so,
Yes, ma'am. Turn your mic on.
If the affidavit or application shows that the voter received assistance, the absentee voter shall be processed as verified. Otherwise, the signatures on the affidavit shall be examined to determine if it appears to be executed by the same person who signed the application. That is 65950 C.
Roman 1C. Well, then that's probably not the reference you were looking for in your amendment anyway.
Well, yes, that's the section that the court had struck down, because we don't do.
The repeal of the signature comparison.
Okay, well,
I mean, if we're taking.
certainly my intent overall is to do what the court asked me to do, and that's a way to cure signatures and training of the election officials. I told Gilles Bissonnette when he talked to me about this some 2 or 3 years ago, I used to look for reasons to accept the signature and not reject it. I used to go back to the printing on the original voter application and compare that with the printing on the request of the absentee ballot, because of things that can vary in signatures and stuff. And certainly, overall, that's the way I would like, but I'm not ready to take that out, so I would encourage 8 through 12 come out, and 13 now becomes 8, and the effective date stays 60 days after passage.
Okay. So on page 6, on line 14, we would add voter address, space for that.
Yep.
On page 7, we would delete section 8, which is on line 20, all the way through page 9. We would delete lines 1 through 6, change line 7 to the effective date to 8.
Section 8, yep.
I would move ought to pass on the underlying.
I second.
Okay. I'm more concerned that you understand what the committee amendment does. Yes, ma'am. Because you're the one that goes and talks to them.
That's why I was repeating it, just to make sure. Tricia was nodding, so.
So on page 6, where on line 14, right now it says voter signature, you want to add a line for voter address, correct?
Add it to that line.
Yes.
The same way it's done in
So
348.
voter address and a line, right? Okay. And then on page 7, starting at line 20, we are deleting sections 8, 9, 10, 11, and 12, which go over to page 9. And then on line 7, it becomes section 8, and the effective date stays the same.
I would move that amendment.
Okay. We have, first of all, we want to make sure we have an auto pass.
Yep, we did.
Okay.
And I think Senator Briggs will second.
All right. Susie Birdsall. And the amendment is 1065 as amended by the committee. Further discussion? All those in favor of the committee amendment, say aye. Aye. All those opposed? And so we're at ought to pass as amended. Further discussion? All in favor say aye. Aye. And Senator Sissy, your choice whether it goes on consent or whether you take it out.
It can go on consent. I'll take it out. consent, if I could.
Okay. All those in favor of consent, say aye.
Aye.
Aye. Opposed?
Thank you.
34.
Okay. Yeah, House Bill 87, I think is one that we can do.
Which one?
87.
So we're not going to do SB 348, right? It's going to be our last bill.
Correct.
348,
That's the political expenditure.
somebody by the name of Gray still needs to work on it. I mean, you know, if he'd worked harder, he probably could have gotten it done, but what can I say?
We didn't really talk about this one.
Where is,
87.
maybe 87, we,
Yeah, election.
and there's probably a disconnect between Shannon and I, because it may have gone into a different folder. Comments on House Bill 87?
Personally, I don't think it's needed.
Yeah, I agreed with a lot of the comments we heard. I mean, I just didn't think it was a needed bill, and I mean, it's usually a neutral zone, you know, inside from electioneering, so I wouldn't be inclined to support it.
I tend to agree with that. I think that we've reached what would be a happy medium, and I believe what really caused this was a hat that says "Make America Great Again." Falls under the law the way it is right now and is a recognizable logo of a campaign that was ongoing at the time.
Yeah, and
So,
I think most moderation and clerks are pretty reasonable about dealing with this and telling people. I know a couple instances where somebody was wearing a T-shirt and it's like, you know, I can't take off my T-shirt. So that, you know, either could you turn it inside out, here's a jacket, it's
11 to 9.
pretty reasonable. I'm not aware of any instances where somebody has been made to do something.
but that,
Huh? I don't know. He is from Derry.
amen.
It's a home court issue.
Uh-huh.
Okay, we'll hold on that one for a minute, because, again, I don't have my folder with me, but, 144.
What was the vote in the House? Do we know?
It was an 11-9 committee vote.
Pretty tight.
Ooh, but I do have a lot of emails in opposition to it. It was a division vote.
Yeah.
Well, okay, the things that I've got marked up on here, it says
Which one are you on?
144, 657-1 says add children. What did I mean to say there? And 657-1 isn't even on there, is it? Then I had a write-up about disability includes physical, mental,
Yep.
developmental condition, et cetera, et cetera, et cetera. I think we've taken care of that in the other bill. And then I says that,
Just phone number and email address, we prefer to have both if you can't reach.
yeah,
Were you guys discussing the docket for 144? Because,
No, no,
Oh.
8-7, but it was 1 to 6 to 1 to 4.
after we exec that one, okay.
I mean, the rest of this one seems to include unincorporated places.
mm-hmm. All right, we'll stick that one
I also
on the
think
shelf
that
again.
It may need to be amended to be consistent with House Bill 292.
All right. And the only other one that I've got, not from today, is 514.
Yeah, the ballot rotation.
I had a note that the Secretary of State was going to bring back.
And he hasn't given us any of that. Okay. So then going to our two bills today, there's only one that we could do anything with.
We
And
did
that's-
we did get an email from the sponsor. I don't know if you saw it.
On 1029? Or what?
The one we heard, the first one, was it 1029?
Yeah.
Yeah. Hold on. It's from Representative Stapleton. Our collective apologies for non-attendance at the hearing on this bill, now currently scheduled. A number of the sponsors have some conflicting circumstances. This bill is merely a housekeeping to amend the omission on last term's bill that enabled the city council to appoint members of the city commission, but inadvertently omitted the authority for the council to dismiss or replace. So,
Certainly, an appointed position like the city manager, as opposed to the elected position, the city council, makes a lot of sense to me. Do I have a motion?
move on to pass.
Second.
Okay, we have a motion on to pass and a second. Is there any further discussion? Call the question. All those in favor say aye.
Aye.
Opposed? Consent? All those in favor?
Aye.
Aye.
Opposed? And Senator Ward, I don't think you've gotten one yet today.
Be glad to take it out.
And anybody else have anything that we need to do before we come out of executive session?
No.
I will talk to the prime sponsor this evening. I have a meeting with him, so, of the logos, so.
Okay. Seeing a motion from
So moved.
Second.
Senator Susie, second by Senator Birdsall to come out of executive session. All those in favor say aye. Aye. Opposed? Our business being complete, we are adjourned.